If you have a smart speaker, you have access to the entire world of NPR and St. Louis Public Radio. All the latest news and all the captivating stories. Activate our voices with yours by telling your smart speaker to play St. Louis Public Radio.
The Missouri House recently passed one of the most expansive abortion restriction bills in the United States. And the sponsor of that measure, State Representative Nick Schroer of St. Charles County, believes that his colleagues sent a big message about where they stand on the issue. Schroer joins us next on the Politically Speaking podcast to break down the different aspects of his legislation and confront the criticism it's received since it's passed. Let's hit the music.
This is Politically Speaking, the longest-running episodic podcast about Missouri politics.
It's a little complicated in Bolivar because there is a Parsons family there.
But we also knew that it was important to make sure that we got to where we needed to go.
You know, if you walk in a room and you're getting ready to make a decision and everybody in the room looks like you need to stop.
And right now what happens in the United States Senate is as critical as anywhere else in the country.
I really want the state to succeed.
Well, we want everybody to know that we're all working together.
I just worked hard to try to build my name where I didn't have the money.
And welcome to Politically Speaking. I'm your host, Jason Rosenbaum, a reporter with St. Louis Public Radio. Joining us through the magic of radio / Comrex field app from St. Peters, Missouri, our special guest today is
Nick Schroer.
Thank you so much for coming on our show. You have not sponsored any bills this year that anybody you're talking about, so we're going to have a really boring conversation over the next 30 minutes or so.
I don't even know if I have any bills this session.
No, I think our listeners can tell we're being a little sarcastic here. You've only sponsored, I want to say probably one of the most significantly notable pieces of legislation of the year, and that's right. HB 126. We're going to get right into it right now. This is called the what is the bill called, by the way?
Well, it essentially started off as the heartbeat bill, which mirrors a lot of different legislation in other states. We're seeing this massive trend of other states passing the heartbeat bills or filing them at least. Mm-hmm. But with the magic of legislating with my fellow colleagues, including amazing leader Elijah Haar, we crafted this into the Missouri Stands for the Unborn Act.
Mm-hmm. And it has been described as either the most pro-life bill in the nation or the most restrictive legislation when it comes to abortion, however you want to term it vernacularly. It's really hard to argue otherwise, because when you look at some of the things that are in this bill, I've been following abortion policy in the legislature for many years. I've never seen some of the things put into one piece of legislation before. So I want you to kind of go through the major aspects of the bill before we start going deeper into why they were there and some of the pushback. So that's my first question for you.
Perfect. Yeah, the first portion is the original heartbeat bill. While a heartbeat can be detected roughly at about 6 to 8 weeks, some of the amendments that were put on actually moves it to 8 weeks and incorporates brain function as well. So at 8 weeks, if a heartbeat or brain function is detected, then no abortions could be performed. And there's some fail-safe language in there, some severance clauses that say, okay, if for some reason, and we included a ton of legislative findings to support our basis in the state's interest in actually protecting lives compared to any of the burdens and minimizing the burdens to a woman in the child that she's carrying. But if for some reason the court were to throw out the ban on 8 weeks, then it would move to 14 weeks. And we've seen through the legislative findings that 66% of the abortions in Missouri, I think even across America, are being performed before 10 weeks. So, and I think once you get up to 14 weeks, the chance of a miscarriage is below 1%. So if the court were to throw out the 8-week ban, it would go to 14. Likewise, similarly, if they threw out the 14, it would move to 18. And then there was a piece by Representative Kathy Swan that included a 20-week ban. And I think she named it the Late Term Pain Capable Act. So a couple other things that were included in there is if it was trigger language by Representative Adam Schnelting. And before I forget, Representative Mary Elizabeth Coleman put the big language in there with the legislative findings and the tiered, 8, 14, 18, 20-week ban. But Adam Schnelting put a piece in there that if Roe v. Wade was overturned, or if a court decision indicates that the states, per the 10th Amendment, would be able to legislate and ban abortion or prohibit it in any way, if that were to ever happen, this trigger language that Adam Schnelting put in would ban abortions outright with no exceptions. Some other ones are two parents would be required to consent to an abortion involving a minor. There are some out-of-state requirements for out-of-state abortions. But basically, we looked at other states. We looked at case law, a ton of case law, incorporated a lot of attorneys into the process, and myself, Mary Elizabeth Coleman, and Elijah Hart are all attorneys. So what we did is looked at what the courts were asking for, so to speak, if they were going to uphold these types of prohibitions on abortion, and we included it in our piece of legislation. So, the Washington Times and other national organizations that have taken a look at this bill, you're right, they have said that this is the most comprehensive or strongest piece of pro-life legislation in I guess history.
Well, before we get into the discourse on it, why do you think this legislation is necessary? If you look at Missouri right now, there are already a host of fairly restrictive laws when it comes to abortion. There's only one clinic in St. Louis, I think, that are performing medical abortions, if I'm not mistaken. The one in Columbia, I think, is still kind of shut down. Like, what is the purpose of this, and why do you think it's necessary to do all the things you just listed?
So my colleagues and I are strongly pro-life. The 100 and I guess now 50 members, since we have a new treasurer. The 150 members that I know who voted on this are strongly pro-life, and we firmly believe that if we can do anything to save at least just one life that was to be aborted, it would be a great success. And that's why we put that tiered language in there. If it's 8, 14, 18, whatever it is, if we can at least save one life and ensure that the future of Missouri is in good hands and is protected, so to speak, then that's a success for us. So that's why I think, even though we do have the ability for individuals to go, whether it's out of state or go into St. Louis and obtain an abortion, we want to make sure that it's not a human being that's nearly fully formed with a heartbeat and brain function, spine and fingers and toes. This is something that I'm very passionate about since I was growing up at a member of Sacred Heart Parish in Florissant, Missouri. And oddly enough, the president of Missouri Right to Life and I went to the same church. And Steve Rupp, who's a good friend of mine, he's now the president of Missouri Right to Life. But when I was a young man and I was cleaning church and a member of the parish, we were in the Holy Name Society together. And he always called me an old soul. But this is something that I'm very passionate about. And I think, like I said, if we can do anything that is illegal, and we think that this bill will withstand judicial scrutiny, anything that we can do to save a life is going to be a great success. And that's why this piece of legislation was necessary.
What do you say to opponents of this legislation who believe it will prompt women who are pregnant beyond 6 or 8 weeks to seek illegal and dangerous ways to terminate their pregnancy?
Well, when you look at I think of the founder of NARAL. It was one of the co-founders of NARAL, who I guess had this fact out there about the coat hanger and back alley analogies with illegal abortions. He came out in a tell-all book and indicated that was false and largely misleading, and that there are statistics out there that show the amount of women that actually died because of illegal abortions prior to Roe v. Wade. That number has skyrocketed since. With women actually dying more with legal abortion. So I think that's a fallacy. I think that whether it's, this state is enacting some sort of prohibition, or if Roe v. Wade were to be overturned, there are still other ways that you could, if you truly wanted to, obtain an abortion until all the states are on the same page. You're going to have sister states like Illinois or somewhere else that's not going to agree with what we're doing here. On the flip side, even though I firmly believe that life begins at conception, and even though the legislative findings in Missouri statutes currently say that life begins at conception, an outright ban, and this is, somebody asked me why I didn't put just an outright ban on abortion. Well, that we know is not going to withstand judicial scrutiny. So being smart about it, we are giving people the option to, seek the whether it's Plan B or seek some sort of medical treatment prior to the heartbeat or the brain function being detected, that's still an option for people. And that was something that was said on the floor. I think, or in conversations, there was a representative, a Democrat, who voted for this, and he was asking about whether this would prevent rape victims from getting the Plan B. And it would not. It would not. So we're looking at roughly at about 8 weeks when the brain and or brain function and or heartbeat is detected. That's when this would essentially kick in. But prior to then, this isn't preventing anybody from getting the necessary medical treatment that would be required if they wanted to ensure that they're not pregnant.
This doesn't contain any exceptions for rape or incest. Is that correct?
That is correct. And we've seen, looking at states like Louisiana, the language that was proposed by Representative Shamed Dogan, he and I did have a discussion offline on how that language had no fail-safe, which actually, what I mean by that is 40 weeks. If somebody is at 40 weeks with that exception, if that would have been put into this bill, that would have allowed somebody to get as long as they signed a document that says, I believe that this baby was conceived out of rape or incest, they could have aborted the baby at any point, including that 40-week mark.
I think that part has been difficult for even people like, I know that there were 3 Democrats who ended up voting for this bill. And I know that from listening to the testimony of Representative Steve Butts, who's from the St. Louis area, I think he really agonized with the idea that there was no exception for rape or incest, because the message it kind of sends is that if somebody gets pregnant through either one of those means, that, and they don't want to keep that child, that because of this, they're basically going to be forced to carry this child to term. Like, how do you kind of combat or at least respond to some of those arguments that just seems kind of heartless on its face in some respects?
Well, I would say that allowing somebody to terminate the pregnancy and kill a child at 40 weeks or 38 weeks, regardless of, that child's value to the parent, that child's value to the nation or to everyone in general, is the same, whether they've been conceived out of wedlock, out of any other form. But that's what I try to speak with Representative Butts about is, look, this would not prevent, number one, would not prevent anybody from getting the immediate care that they need. And if for some reason they don't, and you're past that 8-week mark or the 14-week mark, there is an exception in there for medical emergencies. And as the courts have defined in other cases and in other states, the medical emergency exception could also be linked to whether somebody's suicidal or has mental health emergency. So it's not just physical health; it could be mental health of the mother as well. But me not being a doctor, I'm not one to put those type of findings, those medical emergencies, what they would be defined as. I think physicians would have to take that on a case by case basis. But like I said, in stark contrast to what's happening in New York and Virginia, in New Mexico, we want to stand for life. We want to stand for the life of the unborn. Just like I personally, and I was called on by Representative Bruce Franks, who he's a good friend of mine, despite me and him going toe to toe, whether it's a Twitter war or on the floor. He and I are both good friends, and we have great respect for one another. And he even indicated that I am one of the representatives that he knows, without a question. Whether it's fighting for getting Bobby Bostic out of prison or the juvenile justice bill, that I am fighting for life from womb to tomb. And I'm going to continue to do that, whether some people agree with me or not. But I think, in stark contrast to New York and Virginia, Missouri has made a very loud statement this week and indicating that we are standing for the unborn.
Now, one of the just snap reactions a lot of people have had to banning abortions if a heartbeat is detected or brain activity is detected is a lot of women apparently don't know that they're pregnant like before 6 weeks.
Mm-hmm.
I'm not a woman, so I honestly don't know the answer to like when somebody feels pregnant. But how do you respond to that argument that, the time frame is just too soon to have this type of 6 to 8 weeks is just too soon, basically? Well, how would you respond to that?
I think you can, refer to the conversations and the statements from Representatives Mary Elizabeth Coleman or Sonia Anderson or Kathy Swan or the other Hannah Kelly, all these other women who stood up this week to support what we are doing. That was not alleged. I think it might have been brought up in a statement, not an inquiry of anybody on the floor. But when you couple personal responsibility to ensure partaking in certain acts, and I do understand there are situations where somebody, whether it's a mistake or the birth control doesn't work. I think that there has to be a certain responsibility that you have to know that your actions can lead to life. And once that life is tapped into by form of seeing that there is a heartbeat, seeing that there is brain function, seeing that this body is fully formed, this is the beginning of life. Call it what it is. I've had people on social media call it a clump of cells, but a clump of cells is no different than you or I. We are still a clump of cells. We have a heartbeat. We have brain function, just like this little child that's in the mother's womb. And you find, I think I said this on the floor previously, not this week, but if this type of uh, creature with a beating heartbeat and brain function was found on Mars, the world would rejoice that we finally found life on Mars. But it makes it no different, in my opinion, if it's inside of a mother. So I would just say, it is a travesty that there are certain states in this nation that aren't trying to put precautions in line. That once this life continues and starts forming into a life with a brain and a heartbeat and a little person, rather than just this clump of cells, as people say. I think we need to put precautions in there that actually protect life, and not allowing for the demise of children at 28, 30, 32, 40 weeks.
So in the part where basically abortion would be banned with no exceptions if Roe v. Wade is overturned, why wasn't there an exception for medical emergencies or life of the mother?
I'm not sure. I can't speak on behalf of Representative Schnelting, and I tried to listen to all that debate as best as possible. So I don't recall if there was any discussion on that per se. But I do know that he did bring to my attention that this has been, I think, passed in 6 other states, I'm wanting to say. And I think that he took that language exactly word for word from at least one of those states, if not all of them. I think Arkansas was the last one that passed it. But I do believe that medical emergency might have been in there. Don't quote me on that, because there were a lot of amendments that were included. But I'm wanting to say that medical emergency was in there.
So I want to talk about the two-parent notification part, because this was brought up by House Minority Leader Crystal Quaid. What she pointed out as a potential issue with that is that if you have two parents and one of the parents has abused the pregnant woman in certain ways, as what happened with Leader Quaid, forcing a situation where you have to notify that person and know where the woman who's pregnant and the woman's mother, where they are, could put everybody in danger. I know that you heard that argument. It was a very emotional part of the debate, but it also seems to bring up like a legitimate issue with that idea of two-parent notification, being that if one parent is been violent or sexually abusive and is no longer knows where the other parent is, this could disclose the person's whereabouts. What's kind of your feelings on that? Because that does seem like a legitimate issue with that type of thing, even if what you're trying to do, may have a lot of logic behind it.
So I referred to the sponsor of that amendment, the author of that amendment, Rocky Miller, from the Lake of the Ozark area, and he indicated, and as an attorney, I know this through and through, that there are options that you don't need to get an attorney. You can do it pro se, whether it's filing ex parte order of protection, getting that granted, and that could lead in, and it's going to, in the next couple of weeks. I think that we're going to have some firearm discussions and orders of protection, which we worked on last year in the General Laws Committee. But there are options for families, whether it's an abusive mother, abusive father, abusive family member, where you can get an order of protection, legally barring that person to stay away from you and to not know where you are, or through the family court process. And I used to be a family law attorney before becoming corporate law attorney. There are options that you can utilize to actually terminate that person's parental rights. Now, And any of those options, and that's what I would encourage those people to do if you are a victim of whether it's violence or sexual abuse, to utilize those tools that previous legislatures have put in place for you to use, even without an attorney. You don't need an attorney to do that. But in those types of situations, if you're strictly adhering to the law, there is an exception in our statutes that says you do not need to notify that person, and you can get a court order, and the court would honor something such as an ex parte order protection or the termination of parental rights.
What Leader Quaid mentioned, though, in her situation is that her family was very poor, didn't have access to a lawyer, and then I think, and I'm paraphrasing here, so if I'm getting some of the details wrong, I apologize to you and our listeners. Her mother didn't really have the time or wherewithal to even go pro se to try to get what you just mentioned. So how would that work if somebody just doesn't have the means or ability to go to court to try to do what you just said?
Well, I know that our legislatures in the past, even though they've put a lot of bad laws into place, they put a lot of good laws into place as well. And through the court process, a guardian ad litem could be appointed, fees could be waived, whether it's filing fees or fees for the guardian ad litem for indigent individuals. So there is a process to where the guardian ad litem can act on behalf of that child with the permission of the mother in certain instances. And that's what, the guardian ad litem, and whether it's in an ex parte fashion or whether it's in family law, the court's going to treat all of those situations case by case, very, very eloquently to ensure that they are keeping kids out of harm's way. So, I do feel very bad for the minority leader and any other individual that's going to be put through physical abuse, emotional abuse, sexual abuse. And that's why I think that over the years, our courts have gotten stronger. Now we have treatment courts. Now we have alternative treatment courts. So, if that's something that she still believes we need to focus on, I'd be more than happy to work with her to ensure that whether you're indigent or whether you don't have time, if you're, working 3 jobs, you still have the same equal access to the courts and to the protections of the courts as everybody else.
Would there be any criminal penalties if either a doctor or a woman, if an abortion is performed after the time frame in this bill? From looking at the summary, it seemed like there'd be criminal penalties against the doctor, but
Right.
not necessarily the woman getting the abortion. What exactly would the punishments be if someone violates this?
Well, I believe in the heartbeat bill, and I don't know if any of the other um, amendments changed the language from the original heartbeat bill, but there would be punishments such as fines, and even the taking away of the license of a physician who would be doing this in a similar fashion as what would occur now if somebody is performing an abortion, let's say in Colombia, where you have to have admitting privileges to a hospital, nearby hospital as well. So um, the logic behind that was just to ensure that laws are being upheld to protect life. And we've seen Planned Parenthood out here in the city of St. Louis, where, and I think it was back in 2017 or 18 during the special session when there were many instances of an ambulance taking women out. And I forget how many hundreds of times these advocates said, but that was a major concern as well, even with illegal abortions, is that things are going wrong. So you want to make sure that whether it's now or whether it's once this bill passes and becomes law, you want to ensure that somebody is not a whack doctor or a fake doctor or somebody that is in it for other means. You want to make sure that this person has a legal license to do so and is abiding by the law. And if they don't, I think their license should be revoked.
But what about if you're a woman and you get an abortion past this time? I just want to make clear, would there be any penalties, fines, jail time for them under this?
Per this, no, it would not be criminal. I do not know about the Schnelting Amendment. I'm trying to pull that up as we speak since I am in my office here in St. Peter's. But I do not believe his included any criminal element to it whatsoever. And I think that the bill as a whole would only punish the physicians who are not abiding by the law.
I want to bring up a point that KSDK's Jacob Long tweeted yesterday, because I want to attribute this to him, because this first came to my attention. I'm going to read this verbatim. Just going through the numbers of the heartbeat bill, the state's own fiscal analysis says it's in conflict with Medicaid regulations for abortions, meaning Mo would lose more than $7 billion in funding. State would have to find an additional $7.4 billion in general revenue to cover loss. So what have you heard about that aspect? Because my understanding is there are regulations when it comes to Medicaid and abortion. I understand that the president of the United States right now is a Republican and has talked about wanting to restrict abortion federally, but I would imagine that a lot of the laws that kind of govern Medicaid and abortion regulations are probably going to remain somewhat static while the Democrats control the House. What has been your read on that particular part of this entire debate?
So initially, to poke fun at that tweet, and you just mentioned the president, I would say that point in and of itself, not KSDK, but that point in and of itself would be hashtag fake news, which just to poke fun at the president and his tweeting. But when you look at it, the initial fiscal note that came out, it did include 0 to 7 billion. I dug down deep and sat down with Health and Senior Services, and they figured out, no, there are states in the nation that don't have the rape or incest exception. South Dakota is one of them, and they have not lost a single penny to Medicaid. So after that, they reviewed the fiscal note analysis when this bill went to fiscal review on, believe it was Wednesday morning. I sat in there and there was no mention from anybody. I want to say that it was explained to everybody in fiscal review or fiscal oversight. And I indicated roughly, I think it was in the middle of the debate on Tuesday, since I had heard back from social services that would not actually be the case, that we're more than likely going to lose no money as this has not impacted states such as South Dakota and other states that don't have the incest and rape exception. So the fiscal note was amended. And I think the only fiscal note is going to be on Representative Sonia Anderson's legislation, or her amendment on there, which dealt with literature and handouts to out-of-state abortions.
So I listened to some of this debate over this past week, and I think it goes without saying that the issue of abortion is an emotional one, not only for politicians, but for Missourians. I think for especially people like yourself, are average Missourians who see abortion as taking the life of a child, they're going to see something like this as fulfilling kind of a goal that's been out there since Roe versus Wade happened. But you're also going to hear points of view from what I'm about to play from State Representative Cora Faith Walker, a Democrat from Ferguson, that I heard a lot over this debate as well. I'm going to play this clip right now.
As a Black woman of reproductive age who's had 2 miscarriages, who's trying to have a baby with her husband, though, I am terrified of this bill because the facts are the facts. And any state where, like you say, there's been no combination of such draconian laws and measures in place, but in any state where even pieces of these different components of this bill are put into place, the rates of mothers and babies dying because they do not have access to the full range of health care that they might need, including birth control and including abortion, are drastically different than in those states where women do have access.
You heard a lot of this from your Democratic colleagues that, the decision about whether to have an abortion is a woman's choice and that the government should have no intervention in this. I just kind of see like these two sides are like incompatible. Like, they're beliefs that I think are strongly held by the various parties generally. What do you make of Representative Walker's comments, and how do you kind of address what your Democratic colleagues are saying? Because I'm sure that a lot of people that don't agree with your bill, and I'm talking about actual Missourians, are kind of feeling similarly to Representative Walker right now.
Well, when I heard her story, and my wife and I, we have two beautiful, amazing girls, but yes, we had a miscarriage as well. And when Representative Walker said the facts are the facts, I like to look at facts. I like to do the research, and just like we did on this bill, you see a lot of research from states that have looser abortion laws, and the facts are the facts that abortions are hitting minorities harder and in larger numbers than they are any other race. And somebody who is in Representative Walker's shoes that is not able to have a child. Let's say for some medical reason they can't have children, and they want to adopt. That's where I think we need to start focusing more on loosening regulations and restrictions on the good people of the state that want to actually adopt. That's one of the next steps in fixing our foster care system. But for individuals that cannot have children, um, what do you say to a minority family that wants to adopt a minority child? I think, when we loosen these regulations up, whether it's on the foster care system and adoption, I think that those families are going to actually have options now, where, medically they would have to spend hundreds of thousands of dollars and there's families in my district that have had to do that to try and do everything possible so they could have children of their own. So, I agree with you that there's really no middle ground here. There's no convincing one way or the other, and that's why you saw, 100. I think it was 117 people voting for this, including three Democrats on Wednesday. That you're not going to change their minds after the debate. You feel very strongly one way or the other, and I'm of the opinion that yes, we do need to do more, such as the stats that I mentioned back in 2007. Huffington Post stated that we were near 50th in the nation in terms of states offering disability services and monetary services to families of disability, Missouri or disabled Missourians. Now, I think it was in an article posted, I think in 2015, that we jumped all the way up to number 3. So, yes, we do need to focus on our disabled, on the low income. We need to focus on single mothers, and that's what, partially it's why the Medicaid system is there. And rather than expand it and have more people come into the pool, where we already have physicians that aren't taking Medicaid patients anymore because of many issues with the Medicaid system. I'm very excited to see someone like Todd take over, Speaker Richardson.
Yes, Todd
take,
Richardson, the former House Speaker, but continue.
Yeah, take over Medicaid and implement some changes that we can actually offer the types of care and the types of help that these people that are partaking in Medicaid services, that they can actually get the help that they need equal to that of somebody who has private insurance.
My last question on this topic before we move on to other ones, and we spent a lot of time on this, but I think it's warranted given how important it is. What would you say to people that the best way to prevent more abortions is by making contraception more widely available? And I'm fully cognizant that some form of contraception have a lot of people have religious objections to that. But I mean, the other argument that the Democrats are making is restricting that sort of thing probably would lead to more unplanned pregnancies, and that expanding it in various ways would probably lead to less pregnancies and therefore less abortions. What would you say to that?
Well, when I had this social media post, I put a Facebook post out, didn't spend any money to get more recognition or to spread it out through the state or through the nation, and it's got over 500,000 views and many, many different comments. And there are some people out there that say, abstinence is the best way. Well, I'm not one, and I'm a millennial, and I'm not one to think that abstinence works. For some people it does. For some people, absolutely it works. But I know when it comes to talking to different medical providers out here, and we're trying to tackle the opioid epidemic and drug substance abuse epidemic, and education is key. And I think number one, educating our youth on the risks and the dangers associated and the responsibilities associated, not only with substance abuse and drug abuse, but with sexual activity as well. But also, yes, we do need to figure out how we can get birth control contraceptives and educate people on that as well. And I know there, Representative Sheila Salone has a bill for over-the-counter contraceptives, but I still think, and talking with the physicians out here, there are some risks that some of these birth control methods for women would have that need physician oversight to ensure that there aren't, difficulties or any issues that pop up after using them. So, yeah, I do think, yeah, we have to expand our education to our youth on sexual activity. And I don't think for the majority of people that abstinence is going to work. Yes, it will for some, but I think that educating them on the risks, responsibilities associated with it, and ultimately one choice can change your life forever.
Well, we'll be following this bill because it's going to the Senate now, and the Senate, it's probably going to run into a filibuster there. Whatever happens,
I would bet you it would.
But let's talk about another thing that you were involved in that has elicited some notice, both from lawmakers and, frankly, reporters.
Mm-hmm.
You were the sponsor of an amendment that changed the Sunshine Law, and it was placed onto a bill that was aimed at, I would say, bringing lobbyist gifting and campaign donations on a local level in line with the state level.
Right.
So I want you to explain your amendment, and then we'll kind of, similar to what we just did, go through the pros and cons of it.
Well, when Amendment 1 passed, and that's otherwise known as Clean Missouri, there are a lot of good in it and a lot of bad in it. I didn't want to attack any of the good, but I do want to focus on some of the bad. So with the Sunshine Law that was enacted back in the 70s, now applying to legislators, which it never has been before because of the unique entities that we are. We're not. There's case law out there. I think it's Hawkins versus City of Fayette that says we are not to be classified as employees of the state for the sunshine purposes. But be that as it may, I have been working with House Research, and the floor leader had an amendment on this when we changed our new rules to try and protect confidentiality. And there were some reporters that asked me, well, why don't you just amend the Sunshine Law? Because there is an exception in Amendment 1 that says, now it's going to apply to legislators, but we're still leaving the ability for you all to amend the exceptions in the Sunshine Law.
Yeah, and I think they need to just make that clear as they have in other shows. I think there's been some misconceptions that that Amendment 1, said you can't restrict legislative emails. That's actually not true. It basically resolved that aforementioned controversy about whether legislative emails are open records. I mean, for about 10 years since I've been a reporter, the line from the House and Senate administrators was they're closed records. Clean Missouri passed. Now it's in the Constitution that they're open records, but it does not say that legislators cannot change the Sunshine Law. I think that needs to be emphasized because I think that there's been some confusion over that. But continue.
Well, the two other sources that I tapped into, it was the Missouri Bar's treatise or their guidebook on the Sunshine Law and the history of it and all the exceptions and who it applies to and who it doesn't. And then I tapped into the St. Louis Post-Dispatch's First Amendment attorney, David Martineau. And he was on record of saying that the Sunshine Law and all the exceptions are to apply to legislators in the same way they apply to local governments. And in the Missouri Bar's own guidebook, it says that, let's just say with the Social Security exception, that you can redact or keep closed Social Security records. It says clearly that there is not an exception that would allow local governments to do that. Now, to play devil's advocate, is anybody ever going to sue a legislator because we did redact a Social Security number and won't turn it over?
No.
Realistically, no, I doubt that. But you see in today's politically polarized state that we live in, and not just the state of Missouri, but just, the state of affairs. I want to ensure that the Social Security numbers and private information doesn't get in the hands of other people. So I want legislators to ensure that when they do that, there is no risk of being prosecuted for not abiding by the Sunshine Law. So after the floor leader put that onto the rules and this bill, the Representative Shamed Dogan it came through general laws, and he actually was discussing this amendment, which he started working on. They didn't put it on in the committee, but I, met with the attorneys in House Research to ensure that certain things like what was published by the Post-Dispatch on December 18th, 2018 doesn't happen again. And what I'm referring to, and I've spoken with the author of that of that column, and I told him that, look, it showed me what third parties, not just media, not just journalists, but what marketers could do, what people that are working on elections could do. And that's tap into the databases for free and see who the Republicans are, see who's for gun control, who's for abortion. And what was published on December 18th, 2018 by the Post was an article including Ed Emery's own constituents, and they listed them by name, they listed them by exactly where they lived, and they included the emails that they had sent to their legislator. So what the amendment essentially, what the intent of it was to do, and I think that people really don't have an issue with the first two parts of it. I think it's the last part that they had an issue with.
Yeah, and I just want to piggyback on this, and I don't want to just not say what I've said on other shows. Like, I don't have a lot of interest in sunshining legislative emails, getting emails from constituent X to legislator Y and printing them like you just mentioned, because for me, like, there's not really a whole lot of news value in doing that. I know you mentioned there are other things besides news reporting where that could happen, but I can't really think of an example where I would actually do that. I think, though, the issue with that, and I'm going to read the part that you mentioned dealing with constituents. It says records of constituent case files, and this is language that would be closed under this. For purposes of this subsection, the term constituent case files means any correspondence, written or electronic, between a member of a public governmental body and a constituent pertaining to a constituent's request for information or assistance. I think you're right. The part we're going to get to next is probably more controversial, but I think what people have brought up is, how is constituent defined? If, for example, like a lobbyist or somebody who owns a major corporation lives in your district and is your constituent, then that would be not sunshineable under this. And I'm just going to be I'm going to be open here. I have a lot of problems with closing communications between lobbyists or people that are being paid to do something and legislators. So I want you to address that part.
Well, I agree. I'll be the first one to say that that is not the intent of it. And this is ultimately the first time that we are working on trying to amend this to protect the confidentiality of our constituents. Now, when I worked on this, I had an open door with anybody who wanted to come in and give me their 2 cents. And the people that stood up on the House floor, that they tried. I mean, Representative Carpenter offered an amendment that would only allow for the redaction of Social Security numbers. And this is after in committee they said that we already had the ability to redact that information. I presented my research to them, and I guess they agreed with me and wanted to be able to redact Social Security numbers, but that's half of the issue. I mean, we still have all this other confidential information. But no, that is not what we wanted to do in any way, shape, or form. I think the only constituent that I have that would technically be a lobbyist works for a hospital out here, which is where my wife works. So I've known her forever, but we never communicate in regard to legislation or anything like that. So yes, if there is a situation where, and I think in those types of instances, and this did not come up on the floor, this came up afterwards and talking to different reporters. In those instances, yes, I think that the Senate should be able to fix this language and clearly define that even if a constituent lives within the legislator's district, if they are discussing legislation and they're a lobbyist, I think certain things like that should not be closed. I agree with you 100%.
Let's talk about
No, and I also agree. People have brought up, what if somebody's constituent is a huge donor of theirs and they're telling them how to vote on certain things? I think that should be open as well. So I think this is why they call this the deliberative process, because you have two bodies with many different individuals and many different views, and they can actually perfect this language better than the other side can. I think, having all these people together, they're going to perfect it. They're going to add their changes. They're going to kick it back to the House, and hopefully, in working with certain senators, we're going to be able to do that.
Let's talk about the part that you rightly said is probably the most controversial element of it. It says any record or document, including electronic communications, received or prepared by or on behalf of a member of a public governmental body consisting of advice, opinions, and recommendations in connections with the deliberative decision-making process of said body. First of all, before we get to the substance of this would apply to any governmental entity throughout the state, not just the state legislature. Is that correct, first of all?
Well, we wanted it to apply just as the above language to all governmental bodies when it comes to, and we're talking, municipal governments all the way up to state rep, senator, and statewides, to protect that confidentiality. And it was even brought up, I believe it was Representative Jay Eggleston indicated that this should apply to school boards as well, or superintendents if they're getting confidential communications from parents, whether that's about some child that is deemed a risk, or some other issues such as bullying, that should be kept confidential. So that's the intent of this. Now, this certain language, when I worked with House Research, I told them exactly what I wanted, and I've got in front of me about a 4-inch stack of legislative surveys that I solicit. I solicit views and comments from my constituents. So it wouldn't fall under the other two classifications within the constituent case file. So what we wanted to do is create language that encompass those things, and I send them out regularly. As an advocate for the people, that is how I know how to vote on certain things, such as the prevailing wage last year. I voted in accordance with what my the majority of my district wanted, who responded to those constituent surveys, and they include some personal information. There are some that have ideas on Medicaid. There are some that love me. There are some that hate me. But I don't think that those private views that I've solicited in my position as a legislator using the surveying process, I don't think that marketers or journalists or somebody else should have access to that. I think, similar to an attorney-client privilege, the holder of that confidentiality should be the constituent, the person who actually shared that information. That was the only way that we knew how, using that language, sort of a work product, and that's how I determine how I'm going to vote on certain things, is listening to my district. Even emails, if somebody's telling me, look, I'm a teacher, I don't want you to vote this way, or I'm a construction worker, here's how I want you to vote on this. I think that private information should be kept private, and that's something kind of similar to work product used in the deliberative decision-making process that I think should at least be concealed within the constituent case file.
But would that also include communications you send with other legislators, or when you're talking about making key decisions on things? Because when I've been talking with, including members of House leadership like Elijah Har, my understanding is that would be included under this language. And I'm just going to, if that is true, again, I said that from the onset of this discussion, that journalists like myself have defined feelings on that, on this issue. I just don't really see like intra-communication between members as nearly as sensitive as when you're talking about constituencies. And it's just not a super compelling argument on its face. So I want you to, I want to see if that's actually part of this, first of all.
I agree with you.
But also for you to respond to that.
My mouth is, so to speak. I've had, right after this amendment, was offered and the bill went over to the Senate, I've had an individual sunshine me, and he wanted my communications between myself, Elijah Har, and all lobbyists. And that individual, I still don't know if they want to move forward with this, because we, by law, told him exactly what the price would be to put this on a thumb drive and send it out to him. And we still don't know if that's occurring yet or not, but we're ready. We're ready to send it to him. And I don't think that information should be sensitive. I don't think you should be able to, close off language if leadership is telling you need to vote this way, or you should vote this way. I think the general public should have access to that, to see if the government is corrupt as it appears to be in D.C. That's one of the reasons why I ran for office, and I was totally fed up with the D.C. politics and starting to mesh into Jeff City and different things that you hear. So that's why I wanted to make a change, and that's why I am putting my money where my mouth is, so to speak, and wanting to keep constituent confidentiality or constituent communications confidential. But at the same time, if somebody wants to sunshine their legislator and see the communications between the lobbyist or other individuals that you work side by side, yes, that should be open to the public. But the people that I work for, I think that they need to know that any information that they share with me is going to be kept private, or there's going to be a chilling effect. And if the people aren't speaking to those that they elect, that they're paying the salaries of, who's that person going to work for? Who are they going to take their orders from? It's not going to be the people, because they won't know that anymore. They're going to be taking the marching orders from a third party, whether that's the leadership, whether that's somebody who contributed to their campaign. And I want a government that is led by the people.
My understanding, basically, from what you've said to the responses to these questions, is the language that I just read is probably going to be changed in the Senate, and this may not be the final version. Is that a fair assessment, or are you hard and fast on this particular language?
Oh no, absolutely. I've told certain senators, if you can determine, based upon all these concerns that did not come to light prior to the amendment being offered, even when the Representative Dogan offered similar language in committee, but then pulled it back and said, let's have this conversation on a broader scale. Those concerns weren't brought up, and maybe that's because journalists might be smarter than the elected officials. I don't know, but now that those concerns are brought up, we're working with the Senate to make sure that is there a way that we can amend this language to ensure that my intent is actually obtained, where we're protecting confidential information, but at the same time promoting a fully, transparent government to ensure that there's no corruption. And I think, whether it's from the local levels all the way up to the governor's office, if we can expose any type of corruption, if the government is partaking in any criminal acts, I think the people should know. The people have to know. And that's one of the reasons I worked with a good friend of mine on the other side of the aisle, Representative Gina Mitten, and we included language that would prevent what we heard with the confide applications from last administration from happening going forward. That we want to actually stop that from happening. These secret messaging applications by government officials, we need to get rid of that. That should not be a part of how the government operates.
Well, in our last topic today, since we've spent a lot of time on these two topics, and that makes a lot of. Hang on a second. Okay, I want to make sure I'm still recording. Our last, yeah, that's important. I wanted to talk about a bill that is less controversial than the other two that you've handled, and that is dealing with fentanyl. I want you to explain what it actually does, because I know that the issue of opioid abuse, heroin abuse, fentanyl abuse is a huge problem in suburban places like St. Charles County, where you represent, and also rural Missouri. And I think that a lot of ordinary people may be interested to hear about this particular piece of legislation, which, as I kind of said on the outset, not as controversial as the first two topics we've talked about.
So this bill that I filed it last year, would add fentanyl and any derivative thereof, like carfentanil, to the drug trafficking statutes. Fentanyl is a legal drug. It can be prescribed, but it's prescribed in micromilligram prescriptions. So that's incredibly small. Like a granule of salt would be, I think, above what the legal dosage would be for a doctor prescribing that to a patient. So some people use it for pain. It's you can be administered, I think, in a drip fashion, in a patch. But what we're seeing is drug dealers used to create this stuff, and the legal stuff's being created here in America in labs in a controlled environment, being administered in a controlled setting. But per the DEA's own website, this stuff is being made either in China or Mexico, and then it's being brought up through our borders. And previously, it was being laced into other drugs. They were using it to cut heroin so they could sell more of the heroin, but it would be stronger. But now we're seeing, with its popularity across the United States, is that they're actually trafficking just straight fentanyl. And what we saw, I think it was Friday before this hearing came up, was the Border Patrol busted 260 pounds worth of fentanyl crossing our border, and they got that in their possession, and they indicated that was enough to kill over 50 million Americans with fentanyl in the amount of a middle-aged man, so to speak. So what this would do is add fentanyl and carfentanil, which is even stronger in a smaller form, and any derivative thereof into our drug trafficking statutes. It would also add date rape drugs such as Rufinol, GHB into the drug trafficking statutes, as well as we've seen an increase in those drugs being used for sex trafficking purposes.
And if somebody is convicted of trafficking either one of those things, if this new legislation becomes law, what would happen to them? Would they face longer prison sentences? Would it give law enforcement agencies kind of a tighter ability to go after it? What would be the impact of doing what you just mentioned?
Well, currently we had law enforcement and prosecutors come up and testify, and they indicated that while this is something that the feds can act in on these certain amounts, and they can prosecute for trafficking, they're not, prosecuting these people that only have smaller amounts of fentanyl that are trafficking them. And kind of going off scot-free. But what this would do, yes, it would allow for law enforcement and prosecutors to use this as a tool to actually prosecute these people at the state level. But yes, it would, depending on for 20 milligrams and more of fentanyl or carfentanil, it would be a Class A felony. For 10 milligrams up to roughly 20, it would be a Class B felony. But yes, this would enhance the sentences, as I think it should, because the majority, and this isn't just in Missouri, this is in America, the majority of those that are overdosing and even dying from opioid-related deaths involve fentanyl.
How are you getting a sense that people are getting addicted to fentanyl in particular? Because I think people get the date rape drug for obviously terrible, terrible reasons. I don't really need to explain more. Do you think that it's the reason this is becoming popular is just there's a higher demand among users for it? Or are they getting hooked because it's being put in certain drugs? Like, what do you think is driving this? Because I am obviously not advocating that people that sell these very dangerous drugs escape with zero punishment, because they are affecting lives tremendously. But obviously, like, they wouldn't be selling this if there wasn't a demand for it. Like, what have you heard about, like, why this has become such a problem?
Well, I think the drug in and of itself, and it was the anesthesiologist, a lobbyist for the anesthesiologist, came forward and indicated that this is highly addictive. My wife, she's now a nurse practitioner. She was a floor nurse, and she indicated when she was a floor nurse, when I went to law school in Southern Illinois, it happened, and when she was practicing or a floor nurse in St. Louis and in Lake St. Louis, she had this happen to her where there were patients that had pain patches and then should walk in and they're chewing on the pain patches. And I asked her, well, why would anybody ever do that? And it's because it's highly addictive. So I think when these drug dealers are putting this type of stuff, whether it's fentanyl or carfentanil, and they're not scientists, so that's why people are dying when fentanyl is involved, is because they don't know how to properly administer it like doctors are. It is highly addictive, so they're thinking they're going to get a stronger dosage, and more people are going to want to come back because it gave them a more intense high. Well, what's ultimately happening, they're either yes, they're coming back, but they're not going to come back after they've used so many doses because they're going to end up dying, or they don't come back at all because they are dead from using it. But yes, it's highly addictive, and I think that that's what drug dealers are trying to lace it into stuff so they can get more people to keep coming back. But it's very dangerous, and that's why these deaths that are related to opioids, the majority of them are involving fentanyl or carfentanil. So giving prosecutors, giving our law enforcement the tools to combat this stuff, I think, is one step. The other step is something that I agree with our governor on, and that's more money to our alternative treatment courts. So people aren't going to be encouraged, and they're not going to want to use drugs. They're going to want to go out there and be a productive member of society, give back, help out the communities, and that's what our drug treatment courts are doing.
And where is this in the legislative process right now?
Well, it's in the Senate. Senator Bob Onder, who's a doctor and an attorney, he reached out to me, and he's actually my senator. I've got a great rapport with him, and he knows how hard this stuff is hitting our communities, and that's why he's wanting to carry this in the Senate. So, whenever the Senate starts picking up Senate bills, I think this is going to be one of the first ones to go, as Senator Sater had something related to opioids and fentanyl and carfentanil as well. It was a little bit different than my bill, so I'm not really familiar with what his language says, but I know that I think it was voted out unanimously in the Senate. So I'm hoping that this bill can actually go through clean in the Senate. And if it doesn't, we can deal with it. We can pass it back in the House. But ultimately, if we can get this thing done this year, it's going to go into effect this year and help many, many Americans.
Well, usually we don't do podcasts that are almost an hour long, but these are really important issues and bills that people should know about and hear the discourse about. So I want to just thank you for joining me on short notice to talk about these things. And for all of our stories, stlpublicradio.org. Follow me on Twitter, Jay Rosenbaum. How could people follow you either on social media or any other parts of the World Wide Web?
Well, the best way to stay in touch with me, since I've got a strong German last name that nobody can spell, just go to nick4rep.com. That's www.nick4rep, all spelled out, .com. And you can see my Facebook. You can see my Twitter. You can even get my contact information. So if you want to tell me that you love the fentanyl bill or hate one of my other bills, feel free. That's how this process is done properly, where we can actually advocate for the people of Missouri. So, Jason, thank you for having me on. Anytime you want me back on, let me know.
I will do that. Maybe next time you can teleport to the studio. Although this is actually sounded quite good. Until next time, so long.
The Gateway brings you the day's news each weekday from around the St. Louis region and the state capitals in Jefferson City.
Our schools are accredited. We don't need this bill.
And Springfield.
How many more years must pass before lawmakers see time is of the essence?
I'm Abby Larico. Join me each weekday for The Gateway on the STLPR app or wherever you get podcasts.